Professor Mark Drumbl from Washington Lee University. Mark is part of our series of speakers sponsored by the Saltman Center who speak on a variety of topics. And to introduce Mark in further detail is our very own Professor Christopher Blakesley.
Thank you so much. This is really a pleasure just because it's an honor to have someone as valuable and interesting as Mark here, and also he's a friend. I'd also like to thank the Saltman Center for making this possible. Let me be quick so that we have time for him to do his presentation. And Mark, you can open it up to questions afterwards?
Yes.
And stuff?
Sure.
So that we have time for that as well. And I think we have this. Do we have a mic control for afterwards? We can find someone to do that. Yeah, I think that may be the best one so everybody can hear. Mark is at Washington and Lee, is the class of 1975 alumni professor of law, and he's the director of the Transnational Law Institute there. His topic, which he'll announce as well, I guess, but mass atrocity and traditional dispute resolution. And with a focus on the Rwandan and the Ugandan experiences, both of which are very interesting and unique. By the way, just let me add that he's written a wonderful book from Cambridge University Press, which y'all ought to buy.
That's right. Bye.
And it's paperbound, and so y'all can afford it. And it's a wonderful book. I'm in the process of doing a book review on it, and it's, as far as I've been able to tell, the first major study, nuanced and interesting study of punishment and sentencing in international criminal law, kind of reflecting on the policies, the role of the traditional theories of punishment, for example, among other things, in international criminal law, and addressing the question of whether the Western, I guess we could say, Western approach to prosecution involved in the international criminal courts of all the different sorts is productive in one, promoting the traditional purposes of punishment, and two, promoting reconciliation, remedy, etc. Basically, does prosecution in the Western sense of the idea promote or detract from the hope or the ability to avoid an ongoing blood feud, basically, which often happens, sadly. So I think that's maybe a bit broader than what he's going to talk about, but I assume, Mark, you're going to use Uganda and Rwanda to address some of those things. Sure. Let me just mention also that he's taught all over the place. He just came back from teaching in France. Was it in Paris 2? Mm-hmm. He also has a background similar to mine in the sense that we both got a doctorate from Columbia after law school, so we put our relatives in dire circumstances by going to school forever. So, without further ado, Mark Drumbl.
Well, thanks, Chris. It's wonderful to be here, and I would like to thank the Saltman Center for the invitation to be with all of you here today and to spend some time in Las Vegas, which is always fun. And I'd like to thank all of you for coming on such a beautiful afternoon to talk about a topic that may not necessarily be overwhelmingly optimistic or inspirational, but in it I truly find the center point of what's good and also what's terribly evil about humanity. Namely, how do you prosecute and punish an individual who commits levels of violence that are truly massive in nature? So what I thought I would do today is start off by reading a little bit from my book that I'm delighted Chris mentioned, and for those of you who are particularly interested, I come equipped with order forms and brochures. No, I'm kidding, I have forms though, but I'm not as explicit as that. So I figured I would start off by reading a bit from it. Then I'd like to talk a little bit about how international criminal law responds to these particular crimes as a punishing mechanism. And then I'd like to talk a little bit about how traditional methods of dispute resolution in Rwanda and Uganda respond and the differences between them. So let me start off by telling you a story. And the story is as follows, and it's actually the opening to my book. Beginning on April 8th, 1994, Tutsi escapees, hunted and terrified, fled to the Catholic Church in Nyange, a rural parish in western Rwanda. They sought shelter from attacks incited by Hutu extremists. As you know, the genocide in Rwanda, Tutsi were the victims, the Hutu ethnic group that perpetrated. The attackers were determined to eliminate the Tutsi as an ethnic group and killed individual Tutsi as a means to this end. The church soon filled with over 200,000 huddled Tutsi, many of whom were wounded. These Tutsi initially thought the church, as a house of God, would be a refuge. In fact, they had been encouraged to hide there by parish priests. The priests, however, decided to demolish the church. Accordingly, workers were engaged to operate a mechanical digger. On April 16, 1994, a worker named Anastase bulldozed the church with the Tutsi crammed inside. The roof crashed down. A few Tutsi survived the razing of the church. Nearly 1/3 of the local Hutu population assembled to finish them off. They did so with machetes, spears, and sticks. 4 years later, a Rwandan court prosecuted 6 individuals on charges of genocide and crimes against humanity for the church massacre. Anastase was among the accused. From the case report, we learn that he was born in 1962, was a bachelor, and worked as a heavy equipment driver. He had no assets, he had no prior criminal record. The case report also sets out, through the sterility of legal prose, the evidence underpinning the accusations that he mechanically leveled a church with 2,000 people trapped inside. Many ordinary people in Rwanda were like, or at least were a little like, Anastase. Many others are like him in many other places, countries, and continents. Moreover, many more have the potential to become like him in the future. Ordinary people often are responsible for killing large numbers of their fellow citizens, whether by their own hands, by helping the hands of others, or by encouraging the handiwork. Here, I'd like to address the reasons that existing criminal justice institutions give for punishing perpetrators. And that's the story with which the book begins. How do you deal with an individual like Anastas, an ordinary person who commits extraordinary acts of evil? And the purpose of my research in this is to explore, for starters, the rationales that international and national courts and tribunals utilize when they sanction perpetrators of mass atrocity. And let me underscore that since Nuremberg, crimes such as genocide, crimes against humanity, and war crimes have been stigmatized or cast as extraordinary international crimes. But there's been very limited work on how exactly to punish an individual who commits such extraordinary international crimes. And by and large, there's an acute dependency in international criminal law, whereby the methods and modality of justice available in ordinary legal systems, in particular Western countries, have become transplanted to these international institutions. In my book, I focus a lot on the actual jurisprudence of courts. I don't focus as much on positive law. And we come to a number of conclusions. And what we learn is that almost exclusively at the international level, the form of punishment that's used is incarceration. There are some distant possibilities for reparative justice, but overall, incarceration is the preferred remedy. And if we look at punishing institutions, the International Criminal Tribunal for the former Yugoslavia, for example, approximately, if you calculate the sentences, the mean sentence is about 14 years. At the International Criminal Tribunal for Rwanda, the mean sentence is, in terms of fixed sentences, is about 23 years, but half of all individuals at the International Criminal Tribunal for Rwanda are sentenced to life imprisonment. The third international tribunal I focused on a lot are the hybrid tribunals in East Timor, and there you have a mean sentence of 9.9 years for crimes against humanity. One thing that I think is very important for us to think about is what are the rationales of punishment? In other words, why do international criminal institutions punish individuals who commit these crimes? And we learn that there are three major justifications that are brought forward for punishment. The first is retribution, the second is general deterrence, and the third is what I call expressivism, or performativity. Let me talk about each of those three very quickly to give you some greater background. Retribution, obviously, is the simple idea of just deserts, right? An eye for an eye. That somehow you inflict upon the perpetrator a sanction proportionate to the amount of pain that he inflicted on victims. I argue in the book that the retributive aspirations of international criminal law, as operationalized in criminal trials, fall short. And they do for four reasons. First, punishment for multiple international crimes, extraordinary international crimes, with huge numbers of victims, like 2,000, for example, is generally as severe or less severe than the sanction that's imposed on an individual for committing a single serious, ordinary crime in times of peace. Secondly, retribution in many ways is just redundant. It's impossible to accord an individual like Adolf Eichmann, for example, the architect of the final solution. How does one accord an individual such as him his just deserts without throwing away core human rights standards? There are also inconsistencies in international law among the various punishing institutions, like the statistics I just gave you. International court, staffed by similar individuals, sentences more severely for genocide in Rwanda than it does in the former Yugoslavia. And lastly, retributive concerns run afoul in the sense that there is frequent recourse to plea bargaining, if you can believe that. You can plea bargain to genocide. You can plea bargain, you can cop a plea to crimes against humanity. And although there's nothing intrinsically unjustified about plea bargaining as a utilitarian method of pushing cases through court, when an individual is punished more severely because of information he has and is willing to share on others than someone else, then punishment becomes disconnected from the gravity of the crime and no longer meets retributive goals. The second major aspiration that international criminal law puts forward is deterrence, in particular general deterrence. This is even more problematic, in my opinion, than retribution. Why? First, there's an extremely low chance of actually getting caught. It's, ironically, committing mass crimes like genocide, your likelihood of getting caught is lower than committing ordinary crimes against an ordinary state. But more importantly, general deterrence as a theory of criminal law rests on an assumption of perpetrator rationality. Namely, an individual says, I won't commit crime X because I fear getting punished for crime X. This is a big problem in a situation of mass violence. Why? Two reasons. A, what I call the emotional reason. People want to participate. People in genocidal, extermination, and persecution situations like Anastad's want to participate. They believe they are doing good by eliminating the other. They believe they are purifying society, pushing the interests of their state. They believe that they are benefiting the collectivity by eliminating the threat. Violence is very attractive to individuals who are on a mission to do good. And at a minimum, participants in atrocity are not only captives of social norms, they may even be truly captivated by them. The idea of deterrence in such a context is problematic in my mind. Secondly, for individuals who don't actually share the emotional attachment to the violence, there are others who engage in a utilitarian calculus, who may have the ability to do some cost-benefit analysis. Let's take an example. Child soldiers, for example, my work relating to Sierra Leone. A lot of children participated in gruesome rapes and amputations. Why? They wanted to survive to tomorrow, to next week. They were coerced into violence, and if they weren't part of a marauding group, they themselves would become victims. They had the capacity, perhaps, not to enjoy the violence or believe they were committing a good, but their calculus went to tomorrow or next week. The idea that they would be deterred because possibly 15 years from now they would face a criminal prosecution in The Hague, where if convicted they would be sentenced to jail at a much higher quality of life that they currently enjoy in Sierra Leone, is not going to deter them from committing crimes of amputation and rape today. As a result, when international criminal tribunals rely on deterrence and retribution as goals, in many ways they fall short on the ground. I told you before that there's a third major justification. I call it expressivism or performativity. I think it's the most appealing of the three rationales that are evoked. What do I mean by expressivism? This is the trial as theater. This is the trial as something that tells a story to the public. This is the trial that serves as an educational function, that explains violence, authenticates it as having existed, takes judicial notice of it, creates a judgment that can then appear in a case book and can be taught not only to law students, but all students and society at large. This is the main thing I think the Nuremberg judgments did, and I think it's a very valuable goal that international criminal law and international criminal trials serve. I think, and I can get into this much more in Q&A, in the book I set out 4 concerns with expressivism that I have that suggest that this truth-telling, authentication, pedagogical device is somewhat limited, but I do think it's the one thing that Western criminal trials do well. But here's the problem. The beneficiaries of this performance and teaching are us sitting here. It's not the Rwandans. They knew a genocide existed. They survived it. They know where their country is. They don't need to be educated on what happened there. And in many ways, the benefits of this expressive function go to people like us here now, so that we can learn about what happened somewhere we never thought about before. And I'm not criticizing that function. What I am saying is that it is probably of the least value to the people most affected by the victimization. And in any way, I probably would point out to you that not all that many Rwandans are interested in reading a 600-page judgment in English or in French that is very technical and really is not necessarily all that pedagogically useful or connected to their own life experiences. So as we see, traditional methods, for us traditional, namely liberal, legalist, Western, adversarial criminal trials, and traditional forms of punishment, namely correctional preferences like being sequestered in a penitentiary-style environment, have become the dominant international norm to deal with crimes like genocide and crimes against humanity. Upon more careful analysis, though, we see that to some degree these fall short of their overall goals that they claim for themselves. This wouldn't be so intrinsically disappointing if it weren't accompanied with a second important factor, which is the following. The international norm is pushing out, is squeezing out, is marginalizing other ways in which places can deal with egregious crimes like crimes against humanity and genocide. It is pushing more traditional or indigenous methods of dispute resolution away, in the sense that international institutions assert jurisdiction over perpetrators, but also frame and set the terms of the debate. Here's another shortcoming with expressivism. If the Western criminal trial becomes put forward as the first choice way of dealing with atrocity crimes, it frames an overall debate and creates a specter of suspicion over other methods that in fact may be innate or indigenous to the society in question. So let me do two things in the time that is left. First, let me offer an explanation for why international institutions may continue to operate even though they fall short of their goals. And then let me talk a little bit more about what a more inclusive view of justice would look like, especially in the Rwandan and Ugandan context. I believe that there is a disconnect between the goals of international criminal justice and its output as a dispute resolution mechanism, because the methods of trial and the methods of punishment are transplanted directly from the ordinary criminal law of liberal societies, such as Western societies, that are rooted in certain assumptions of individual agency and individual behavior. In particular, our criminal law system is rooted in the assumption that the perpetrator of crime is a deviant individual who transgresses, who violates social norms. It's someone who counters the overall goal of society and as such should be punished and should be held accountable for his or her agency in violating social norms. However, the perpetrator of mass atrocity is not like the ordinary common criminal. The perpetrator of mass atrocity is not a deviant. He's not a transgressor. In fact, he's a conformist. He's an acute conformist. Deviant people in Rwanda in 1994 refused to kill the other. Conformist people participated because they thought they were doing good. And this isn't just Rwanda, it's just the place that I've worked, so I talk about it a lot. It is the same pattern in all situations of mass group-based violence. So here we have the major problem. We've said, international legal scholars have said, that genocide and crimes against humanity are different from other crimes, hence they're crimes against everyone, such as crimes against humanity, and they're very much substantively evil and different and should be stigmatized. But, although we've created this special heinousness to the crime, we've just relied on ordinary measures of punishment central to Western societies as the way in which people are prosecuted, sentenced, and punished. And the latter is based on a theory that the perpetrator is deviant, whereas psychological, anthropological, and journalistic research will suggest that the perpetrator of mass violence is not really that deviant. And this dependency on ill-fitting domestic approaches, I think, is the theory that I bring forward as one of a number that suggests why there's a shortfall in international criminal law. So it's easy to diagnose, a problem. What do you recommend then as a remedy? And in my book, I suggest two forms of reforms to the architecture of international criminal law. One is a vertical reform that is more inclusive of traditional forms of dispute resolution, and another is a horizontal form that says, look, these are crimes that need to attract much more than just the criminal law. We need to have civil sanction, we need to have a conversation of collective responsibility, and we also need to look very much beyond the law, something international lawyers or lawyers in general are not very good at or prone to do, and we need to think of other ways in which justice can be activated. So, this is a good opportunity to talk about the kinds of traditional forms of dispute resolution that I would like the international architecture to be more receptive to in terms of welcoming as opposed to squeezing out. And the two case studies that I want to talk with you about now are Gacaca, G-A-C-A-C-A, which is a traditional form of dispute resolution in Rwanda, and Mato Oput, which is a traditional form of dispute resolution in Uganda. So we've got Gacaca, Rwanda, and Mato Oput in Uganda. Gacaca. Traditionally in Rwanda, disputes were settled by local elders gathered together within a community in a bottom-up process in which individuals would come forward, would discuss in community the violations of the social norms that occurred in that particular time, and then individuals would, through ritual, become reintegrated into the community as a whole and welcomed back. In 2001, the government of Rwanda instituted a law that was passed called the Organic Law on Gacaca jurisdictions that created a national system of Gacaca courts to deal with perpetrators of genocide. Now, what has happened since then is approximately 100,000 people have been adjudged by these Gacaca tribunals, and the trials that have occurred have given rise to accusations against 800,000 more individuals in terms of the evidence that was proffered. This is all in a country of 8 million people in total. The genocide in 1994 was ended in July of that month when an army called the Rwandan Patriotic Army invaded Rwanda from Uganda. It was a Tutsi-based army. It was an army based from members of the group that had been targeted in Rwanda for genocide, although members living in other African countries. They invaded the country. They remain in power today. So Rwanda is a dictatorship today in which the minority victims of the genocide are in power. Of course, the human rights abuses committed by this government pale in comparison to those of the predecessor government, but the country nonetheless is an authoritarian situation. The government has launched one of the most assertive attempts to try and bring perpetrators to justice. And in that spirit, reached back to traditional forms of dispute resolution, like Gacaca, and modified them through state-centered national legislation to prosecute individuals. So, one question that I address in the book is whether the Gacaca system would satisfy international scrutiny in the sense that an international institution, such as the International Criminal Court, may, for example, allow local trials to continue and not assert jurisdiction over perpetrators in the gacaca system. I think the answer to that is no, and I wish that the answer to that were yes. In the gacaca system, you have local judges that are elected by the population. They sit in panels. Perpetrators are brought back to the community in which they are alleged to have committed their crimes. There, they're adjudged in public. Witnesses testify in public. Gacaca actually means justice on the grass in Kinyarwanda. And what ends up happening is there is an innovative form of sanction that is attached to gacaca, where individuals, in particular those who plead guilty to their crimes, are eligible to spend up to half of their sentence in community service. So an individual, there's categories of offenses that are created, and there's a different regimen set up for those who found guilty after trial, those who plead guilty after already being accused, and those who just come forward and plead guilty without being accused. The latter group is treated the most favorably. But in all cases, depending on the category of offense, an individual can spend about half of his or her time in community service and can also benefit from a suspended sentence of 1/6 of the overall time that is allocated. I think that one thing the gacaca system has done is it has proven to be somewhat more of a cost-effective way of processing very large numbers of detainees. When I first wrote the book, it was not long, it was a year ago, gacaca hadn't really started in earnest. It's really started in earnest this past year. And I have to say I've been a little disappointed with the overall outputs of the process so far. And to me, that's a very important lesson to realize that whether you look internationally or locally, atrocity is a hugely complicated thing, and there are no simple solutions to any type of reintegration, rehabilitation, justice, or reparation. We have to learn to be extremely modest about any kind of initiative and what it can or cannot do. So I've become a little disappointed. But I haven't become disappointed so much with the idea of traditional forms of dispute resolution. I've rather become disappointed with the fact that the Rwandan government has manipulated the traditional method such that the gacaca law, in particular more recent versions of that organic law, have pushed gacaca to look more like a Western criminal trial than the traditional form of dispute resolution from which it first emerged. And what I mean by that is the following. There's been a lot of pressure from international donors and foreign aid agencies who are like, hey, there's no lawyers in this gacaca thing, there's no way to corroborate evidence, what type of a legal institution is this? And a lot of donors didn't understand that traditional dispute resolution methods are often much more social institutions than they necessarily are legal institutions keyed towards finding individual guilt. And I argue, and I foreshadowed this in the book, and I saw it coming, and it's coming, and it came, and it's happening. It has become much more like, the pressures to make it more like a Western trial have sapped, I think, some of the reintegrative and rehabilitative aspects that this particular form of justice otherwise might have. Also, the government has manipulated it to bring a number of accusations and denunciations against people, not because of what they did wrong during the genocide, but rather as a tool of political intimidation, and has brought accusations against individuals who have done nothing but oppose the government, even if they had nothing to do with genocide in the first place. And that's corroded it a little bit. And I guess the third concern that I do have with it is traditional gacaca dealt much more with property offenses. It did deal with violent crime on occasion. It didn't really deal full frontally with the idea of genocide. And inevitably, there are going to be some difficulties in adjusting a traditional method to the situation at hand. All that said, surveys of Rwandans and the realities on the ground in Rwanda do suggest the following. Notwithstanding the flaws of Gacaca, it is viewed as the most obvious, the most credible, and the most legitimate way of dealing with genocide, much more so than international trials run by the United Nations, much more so than trials in foreign countries of genocide suspects, and much more so even than formalized trials that have taken place in Rwanda in the late 1990s. So I think there's two valuable takeaway points on the Gacaca system and the summary I've given of it to you. A, local justice isn't perfect. We cannot sit around and venerate. You know, a lot of Western scholars really have this tendency to venerate, to be fascinated by anything that's indigenous, right? The reality is, a lot of these methods of justice are deeply fallible, susceptible to corruption, manipulation, just like any other system of justice. We can't worship it. We can't be naive. But secondly, the potential that it had, and that I saw in it, and that I believe in it, has become compromised because the government has manipulated it to serve much more the function of a Western criminal court than its traditional social institution. And that, you can't blame the institution for. You have to blame the process. We talk for 5 minutes about Rwanda, and we'll there see a very different story. Mato Oput has a lot of similarities to Gacaca. Community, together, conversation, ceremony, process, reintegration of perpetrators after atonement, and quite possibly after some form of reparation. Uganda, the problem is the following. The International Criminal Court, which came into effect in 2002, has judicialized a 20-year civil war in Uganda between the government forces and a rebel army in northern Uganda called the Lord's Resistance Army, led by someone called Joseph Kony, who is an extremist Christian in his own way, and has led this fighting force that has committed egregious violence in northern Uganda, mostly through a child soldier army, rampant sexual violence, mutilation, and atrocity and crimes against humanity. The war's been going on for a long time, and the Ugandan government doesn't have clean hands either. The Ugandan government itself has committed human rights abuses. It referred this violence to the International Criminal Court, which has issued 5 indictments. One of the indictees has subsequently been killed, so we're down to 4. Here's the problem. The leaders of the Lord's Resistance Army, who have been indicted by the International Criminal Court, say they will keep on fighting and won't surrender or won't negotiate for peace because they've been indicted. In other words, the indictments issued against them have proven to be a disincentive in peace negotiations in Uganda, because the sad reality is often you do have to barter away justice for peace in lots of these conflicts. And, you know, in many societies, systematic human rights abuses are ignored because the perpetrators say, hey, I'll relinquish power if you amnesty me. For the lawyer, the word amnesty is an evil word. For the political scientist, it's a necessary way of doing business. And in Uganda, we have a situation whereby the indictments by international criminal institutions arguably have extended the war and made it more difficult to arrive at peace. They've also squeezed out local forms of dispute resolution like Mato Oput, which actually involves ceremonies with eggs and twigs. There's a real ceremonial aspect to it that may seem odd. I'll be honest with you, it's unusual to me because I'm not socialized in this particular method of justice. But the point is the following. lots of people living in the war-torn areas of Uganda would appreciate the idea of Mato Oput and traditional dispute resolution, in particular to reintegrate child soldiers and other forms of combatants for whom the lines of criminal responsibility are somewhat shadowed. But with the entire focus on international criminal law, what has ended up happening is there has not been a sustained conversation about this traditional method of dispute resolution as something that could be implemented. I'm going to make a final comment, which is a new takeaway point that builds on the prior takeaway point from Uganda, which is this, namely, sometimes law and indictments may create trouble, they may just not solve trouble, and other forms of dispute resolution might very well serve reintegrative purposes without the stigma of the criminal law. And my final takeaway point is this: money, or cost. Every conviction at the International Criminal Tribunal for Rwanda has cost, on average, $30 million. Per capita GDP in Rwanda is $1,500 US a year. The US dollar has been pretty weak on international money markets. Maybe the per capita GDP is now up to $1,650 or something, or $1,700, right? It is incomprehensible to the average Rwandan of the cost of justice at the International Criminal Tribunal. That money could have been reallocated to alternate purposes, I would argue. And let me talk about another African country, Mozambique, which ended a 10-year civil war with egregious levels of violence through Mozambican traditional methods of dispute resolution and reintegration that one political scientist has estimated cost $2,000 per reintegrated perpetrator. Now, I'm not saying that you can attach a price tag to justice, but you're going to leave law school soon, and you'll realize in the real world, there's a price tag to everything. You have a pie, and it's of a fixed size. I don't know if rising tides, lift all boats or not, but the point I'm trying to make is the following. Justice costs money, and I would like, perhaps, if we recognize that there may be alternate forms of dispute resolution that may not only be more effective in reintegration, that may not only be more effective in restoration, but also may be able to do so in a much more cost-effective manner. So by way of conclusion, I'd offer you the following observations. When we think about terrible crimes that are committed, I think what we need to do is not become prisoners ourselves of Western criminal law. We need to realize that we need to do much more than criminal trials. We need to do much more than inject our value system elsewhere, especially when, at least in Rwanda, when push came to shove, we refused to actually follow through on our value system and stop a genocide. And we need to think about moving international criminal law to a much more all-encompassing law of atrocity. And the final lesson I would leave is this. We need to learn a virtue that lawyers generally don't have. And that's the virtue of modesty. The virtue that law is not a cure-all, law is not a solution. Law is not neutral and impartial, that solves all riddles and answers all problems. Law actually does little. We need to admit that, relish in it, and realize that to truly solve issues of intractable political violence and terrible crimes, we need to bring a lot more to the table than a handful of extremely expensive criminal trials. And we need to be a lot more open to what victims in conflict societies might want. And instead of ridiculing, like a lot of international human rights observers do, ridiculing things like Gacaca and Mato Oput, we need to recognize their limits, but do so in a welcoming and supportive way that recognizes the diversity of justice and the plurality of the human experience, even when it comes to condemning universal crimes. So I guess we have about 10, we go till 6, so we have about 10 minutes. So if any of you have any questions or reaction or feedback, I'd be very happy to hear from you. And if any of you are interested in any book stuff or want a little postcard, I think I shoved some in here, but I'll get them afterwards. Yes, you had a question. Yes.
Thank you very much for this very interesting talk. I have 2 questions. The first one is this. I take it from your presentation. I assume that you are not necessarily saying that these international prosecutorial efforts shouldn't take place, but that these should take place in combination with local regional dispute resolution systems. If this is a correct understanding, what is the relationship between 2 different systems? What kind of ratio should there be, for example?
Okay, I think that's an outstanding question.
I have another question, if I may.
Okay, how would I answer that? And then you ask, because I might forget your outstanding question. So, okay. Right now, the relationship between international and national approaches is called complementarity. And that's Article 17 of the Rome Statute of the International Criminal Court. And that provision says that international institution will assert jurisdiction if national institutions are unable or unwilling genuinely to investigate and prosecute. In Chapter 5 of my book, I argue that complementarity creates the following incentive. No national institution wants to be stripped of jurisdiction over something. Hence, national institutions will mimic international institutions because when it's the international institution who decides whether or not a local institution is willing or able genuinely to investigate or prosecute, the international judges decide, and it's much more likely they will permit a national institution to go forward if it does exactly what the international institution is doing, right? So that's psychology 101 of the way that it works. I instead suggest a test in the book that I call qualified deference. It's a different test than complementarity. There I say that the presumption should be that the national or local institution goes forward. The presumption is one of deference. The international institution defers to the national, and that should go forward. But the deference is qualified. In other words, I set 6 criteria that might limit the deference. And at the end of the day, I come out in a situation where I would be more permissive of national and local approaches than international institutions, but I would not give a free pass or carte blanche to national institutions to go forward. One final comment on your first question. Complementarity under the 2002 International Criminal Court is already a step beyond what existed before. The Rwanda Tribunal and the Yugoslav Tribunal, both of which were created in the Security Council resolution, Yugoslavia in 1993 and Rwanda in 1994, both of those have the following standard: primacy. The International Tribunal is completely primary over any national approaches. So that's where I would come out. So, and in the book I talk about some very problematic case studies. One I look at is in Afghanistan, and I look at traditional forms of dispute resolution, the Pashtunwali, which is a customary code of law in the Pashtun region of Afghanistan, where one of the ways in which wrongs are righted is through compensation and restoration, where the family of the perpetrator gives livestock, money to the family of the victim. Another form of chattel, though, are young virgin girls that are transferred from one family to the other. So that really, what do? And let's assume that's a credible form of justice locally. I would say that runs afoul. One of my conditions of qualified deference is that the local system of justice cannot inflict great evils on innocent third parties. And I argue in the book that a 12-year-old being put in a situation of sexual terror and forced marriage is precisely that kind of a wrong. So your second, right? You can ask.
You actually answered my second question.
Okay, good to see you.
Thank you.
Any other questions?
Yeah, I'm going to cop
Oh,
the mic since it's next to me.
oh, okay.
Follow up. I think I know the answer to this, but is one of the ways to qualify, merge, allow a relationship between the ICC approach, for want of a better term, and local systems, local processes or mechanisms, to allow prosecution of the worst, right? Which would do the expressive element pretty well, it seems to me, and also function, it seems to me, pretty well in a retributive sense. And I don't know if it would deter, because megalomaniacs, they think, I suppose they got hubris enough to where they won't be deterred anyway. But even in domestic systems in
Right.
the West, who believes in deterrence anyway? Do you think is that what you mean when you say accommodation among them, or is that part of it, or could it be part of it?
Yes, I also think we need to expand the conversation. I think, for example, we want to talk honestly about collective civil sanctions on groups. The major condition precedent of this violence is that massive numbers of people participate in it. And I think we need to have a conversation not of collective guilt, but of collective responsibility, of civil sanction, of truth-seeking approaches. And remember, all of this is predicated on the following, which is an idea gains ascension. It becomes influential and dominant. And now, when we think of this violence, we immediately think of the Western criminal trial as the response to it. I'm not saying that Western criminal trials should have no place in the puzzle. What I am saying is we need to stop thinking about the Western criminal trial as the reflexive, the primary, the immediate, the first best and only solution. We need to change our mindset. And fundamentally, what I'd like to do is recognize that a lot of people have spent decades in their whole careers saying we finally have an international criminal court, we finally have people being brought to justice, and that's good. But we need to grow beyond that, and the only way to grow beyond that is to recognize the limits of what we've accomplished. So I guess that would sort of be the answer, and I think you had a question.
Yeah, I have a two-part question, actually. First is, do you ever envision egregious human violations of international law, like genocide, as encompassing that additional, I guess, criteria that expands genocide to political or ideological associations? And if so, do you feel that this sort of compromise between locality and universal prosecution for such crimes would change in that perspective?
Yeah, it's a good question. So genocide under Article 2 of the Genocide Convention, which is now Article 2 and 4 of the Rwanda and Yugoslav statutes, and Article 6 of the Rome Statute, define genocide as a series of violent acts, that's the actus reus, committed with the intent to wipe out in whole or part, or to destroy in whole or part a group. And there's only 4 groups that are protected groups, right? National, religious, racial, and ethnic groups. So, international prosecutors have faced some hurdles. It was a controversial decision at first in Rwanda, whether the Hutu and Tutsi were actually ethnic groups or not. Tribunal ruled yes, contributed to the body of law in that regard. It's a controversial conversation in Bosnia. Genocide was only proven at one place in one case so far, the Radoslav Krstić case at the Srebrenica massacre. It's going to be an issue in Cambodia, right, whether or not the genocide actually occurs there. At Washington and Lee, one of our upper year international law courses involves, we've got 8 students now who are working for the defense at the Cambodia Tribunal. And that's a big issue that the defense lawyers are going to raise forward. But I have the following answer to your question. I think this is very interesting. If the formulation of international law were more bottom-up, the conversation would open much more as to whether the definitions of protected groups should increase, should expand to cover social groups or occupational groups, political groups, sexual minorities, disability. There's lots of other categories on which widespread violence is inflicted on individuals that don't count as genocide. So it could also be that opening up the procedural aspect of the conversation, because fundamentally what I'm calling for here is the following, right? I say, the book is what I call a cosmopolitan pluralist approach, right? In the sense that it's cosmopolitan in that I believe in certain universal shared norms. And the universal shared norms I believe in is that there is such a thing called great evil out there that takes the form of genocide and comes against humanity. And I believe that's a universal characterization. And I believe universally that victims are entitled to accountability. But I'm pluralist in the sense as I believe there's many procedural ways to get to yes, to get to the enforcement of that one universal norm. And hence I'm procedurally pluralist, in particular on the sanction. But what's interesting is that it could very well be that if we involved more bottom-up collectivities in the process of justice, the substantive universal definitions also might change to some degree. And I don't think that's a bad thing. To me, that's law in a state of maturity and development. So that's how I would answer your question.
As I understand, after East Timor, Indonesia proceeded to prosecute a number of people who were involved in mainly murders of UN personnel. We saw sentences of 2, 3. There may have been a 4-year sentence for murder. But it's something we generally consider staggeringly low. From what I recall, I may be wrong about this, the international community made relatively very little protest about this sort of thing. How does that fit into what you've been talking about, bottom-up, top-down approaches? And are there any insights into Indonesia's prosecutions?
Okay, excellent question. So East Timor, for 3 years, from 2002 until May 2005, had an internationalized tribunal, the special panels, a serious crime unit of the special panels in the court system in Dili, the capital of Timor-Leste. A little bit of background: in 1999, Timor-Leste voted in a plebiscite for independence from Indonesia. The response was that Indonesian-backed militia forces in East Timor inflicted widespread crimes against humanity, property damage, about 1,000 people were killed. There were 350 people roughly indicted by the special panels. 83 people were actually prosecuted. And that's where I get the sentences of the 9.9 years on average for the extraordinary international crimes, mostly crimes against humanity. 3/4 of the indictees were never prosecuted. Most of them are living freely in Indonesia. And there has basically been no justice, all right, in the Indonesian context. So, does that mean the following? Are there times and places where local justice is impossible, and the only thing that we have left are international institutions? I would say the answer to that is yes. And I would say that Indonesia is one example. Chile is also an example. The thing that got the whole ball rolling about justice in Chile was foreign indictments in Spain against General Pinochet. That's where it all started with regards to the House of Lords decision in the late 1990s when he was in the United Kingdom, and should he be extradited or not. I will add as one not so ironic caveat though. Spanish courts are very assertive nationally in terms of prosecuting atrocity elsewhere. Let me add one caveat. Spain transitioned from decades of authoritarianism under Franco without a single prosecution and a strategy of forgiving, forgetting, amnesia, and amnesty, right? And Spain has a very vibrant democracy and did quite well. Well, it won't let other countries do what it has done. This is just an aside. But I do think there are times and places for international judgments and for foreign court activity. But that should be the last step, right? First, you should make a good go of domestic approaches. And one thing that the Serious Crimes Unit, East Timor, did not do all that well is reach out to traditional forms of dispute resolution among the Timorese population. Instead, a Commission of Truth and Reconciliation did a little bit better in terms of its approach in Timor. So I think that's one important aside. But I would also say the following, that international interventions are always going to be conditioned on politics, and that explains Indonesia to some degree, in the sense that I think that there is a grave concern of destabilizing the country through too much justice. Well, let me put up a more difficult counterfactual to yours about the local justice idea. And I gave a lecture on this in Ireland, and an Irish student put this to me there. So, you think local approaches are good, like the Cha-Cha, Mato Put, and all that. So, I guess by that same token, you would think that Guantanamo was fine as well, right? You know, this is a local approach that has obviously been given a lot of reflection by the government. And, hey, you know, I argued in prior publications that the 9/11 attacks were crimes against humanity, and I argued that the appropriate response thereto ought to have been an international tribunal, right? If we force all these other people to have their tragedies internationalized, why not ours, right? Well, we didn't do so. And in fact, whenever I put to an American audience, like, imagine if Osama bin Laden were captured and were tried in, I don't know, Delhi by a Finn, an Ecuadorian, and a South Korean national, was prosecuted by someone who speaks English, a New Zealand national, let's say. You know, Americans are all up in arms. It's crazy. Well, it's the same system we created for Rwanda, right? But hang on. But I guess what I would say is the local isn't perfect, and if I think a Cha-Cha is okay, why would Guantanamo not be okay? And I think that's truly I think one of the most effective critiques of my argument. Tragically, the Bush administration has made the response easy for me, namely, I believe waterboarding, coercive interrogation, torture, and 6 years of detention without habeas corpus is no less of the infliction of a wrong than the situation I described in Afghanistan. So that would be my answer.
The scenario you described, though, if the international community actually went out and got bin Laden, isn't that really what would happen as a matter of course? They wouldn't surrender him over to the United States because of the death penalty. The same as you described, I believe, in Chapter 4, occurring with Norway, wasn't it, prosecuting...
yeah, since Rwanda has abolished the death penalty in July of 2007, it just gave up. Or it wouldn't have been able to receive any cases from the ICTR.
Even though it had never prosecuted.
Right.
Even though it had never enforced it.
Well, it had. 22 people were executed in Rwanda in April of 1998. But there have been no executions since then. Well, the other thing is, though, here's another point that we have to understand. We seem to think that international institutions are somehow above politics, but let's get real. There are 3 situations that are being dealt with right now at the ICC. Sudan, Uganda, the Democratic Republic of Congo. Other cases are potentially in the pipeline, Cote d'Ivoire, Ivory Coast, and Central African Republic. One of the problems with international justice is that, although it's supposedly neutral, it only becomes operationalized in states that either can't resist the assertion of jurisdiction or have no national judicial system to speak of. So I do worry, and this is what I worry about the most when it comes to Western responses, and I wrote about this in an earlier article, and that is this. The West, the United States in particular, the West in general, is a huge backer of international criminal justice institutions, ones that are created by the Security Council, so that it will never assert jurisdiction over Americans, but huge backer from Nuremberg forward, loves this model, gives a lot of money and supports it. But it's very disappointing to me that we obviously don't believe our own rhetoric, because due process and long trials and pleasant conditions of detention And all of that is wonderful. We're going to force the Bosnians and the Rwandans to deal with that and see their tormentors benefit from that. But we don't really believe that, because when this country was attacked on 9/11, law went out the window and down the toilet very fast. And we forbid, the things we forbid the Rwandans to do in their suffering, we've done for ourselves, right? And to me, that's disturbing. That's quite disturbing, because it just shows I don't think that, criminal law is a cure-all to these situations, but we cannot have a system of law where we impose it on the weak, but when the strong become attacked, we don't abide by it. That's not a system of law anymore. I'd rather just live in a state of nature.
Sorry, have we at any time actually enforced these things on a country like Rwanda or East Timor when they're actually in the middle of the conflict? When they still...
Yeah, only the former Yugoslavia. The ICTY was created in 1993. And actually the worst violence in the former Yugoslavia occurred after. And actually, there's a very interesting book. I'm not sure if it's translated in English yet, but it's by the ICTY prosecutor, Carla Del Ponte. Her press attaché, a woman called Florence Hartman, wrote a book in French called Pays et Châtiment, Peace and Punishment. And it is a strong critique of the politics of the ICTY. I think it's been translated, and you might find that interesting to take a look at how Milosevic was great to negotiate with at Dayton, and then all of a sudden a few years later it became this terrible war criminal. So, but I think this is a universal signal cross-culturally that it's over.
Thank you so much.
And I will, if any of you are interested, I've got a couple of postcards for the book, and if that interests you. They're right here. Thank you. Well, I don't know about that. That was well. Here you go. Oh, good. I like food. Okay. I will. Yes. How much in the morning? I have my San Francisco flight is at. So is there a rush hour? I have one bag. Oh, thank you so much. Yeah, I would really like that. Yeah, take care. I'll just get